We now come to the discussion on Title 7 of Book 5 of the Labor Code, which deals with grievance machinery and voluntary arbitration. Grievance is any question, either by employer or by the employee, arising from the interpretation or implementation of collective bargaining agreement. It could also be with respect to interpretation or enforcement of company personal policies, like, for example, issues about vacation leaves, issues about wages, and even with respect to the economic and non-economic provisions of the CBA. The law requires that its collective bargaining agreement must provide in its terms and conditions grievance machinery procedure, or the grievance machinery clause, wherein its purpose is for the settlement of labor management disputes arising from the interpretation or implementation of the CBA, as well as the enforcement of company personnel policies. Unresolved grievances, it will have to be referred to voluntary arbitrators, which at the time of the negotiation, the parties to a collective bargaining could readily identify the voluntary arbitrators, or if there are no voluntary arbitrators that are named or identified, then it would be the NCMB, the National Conciliation and Mediation Board, that would appoint for voluntary arbitrator or panel of voluntary arbitrators. Pag panel of voluntary arbitrators, it means that there could be 2 or more arbitrators that would be sitting to resolve the grievance that are provided. Grievance procedure, it is the system of settlement of the grievance now at the plant level in a collective bargaining agreement. So every collective bargaining agreement, it must have a provision on settling of grievances, and it must have provisions on grievance procedure. The essential requisites for a good grievance machinery, it must have definite subjects for settlement. It must readily identify which would be the subject for grievance. Usually, this would of course include issues pertaining to the economic and non-economic provisions of the CBA, as well as we have already identified also with respect to implementation of personnel policies. Pag sinabi nating personal policies, policies pertaining to employment and the treatment of employees. Proper person or body to whom the grievance must be brought. No, the party should designate the person or body to whom the grievance must be brought. This is designed for the convenience. Kung saan siya ipa-file, if there is a grievance, dapat identified na kung saan siya. Usually, sa mga companies, they have yung grievance committee. So usually, merong na-form na grievance committee where in case there is a grievance or there are issues pertaining to collective bargaining agreement, doon ipa-file yung complaint for grievance. And provisions for a mode of appeal na in case there is already a resolution and a grievance and the other party is not satisfied with the decision, then he could always make an appeal. And the manner of making an appeal and the body or authority to whom the appeal must be made, it has also to be indicated in the collective bargaining agreement. And also the finality of settlement or adjustment. It determines when a resolution or decision becomes final, kasi otherwise walang magiging katapusan, walang magiging end ng grievance, walang magiging resolution. So the grievance procedure must provide for a finality of settlement or adjustment. When does it end? And at the same time, so that there is a manner by which to execute and to put an end to the controversy. And also for the provisions for statute of limitations, no? When it is no longer a period, it is a period when it is no longer where an appeal could no longer be entertained, no? And so kapag nag-lapse na yung period to make an appeal or the period to file an appeal under decision and a grievance, then that appeal could no longer be entertained. That is the statute of limitations. In the absence of specific provisions in the collective bargaining agreement, no, an employee shall present his grievance to the shop steward. Sino yung shop steward? Usually kasi sa isang company, especially in a manufacturing company, may kanya-kanyang unit sa production. Like there is a unit na sila lang yung nagpre-prepare lahat ng mga ingredients, no? Then there is a unit na halimbawa sa Century Tuna, sila lang yung ginagawa lang nila ay nagkakaliskis lang ng isda or nagpe-prepare lang nung isda na magiging na ilalagay sa can. And then meron isang portion naman na ang ginagawa lang nila is sila yung naglalagay sa can nung isda together with the ingredients. Tapos meron naman isang area, isang unit, another unit of the production na what they do is sila yung nagsiseal ng mga cans na meron ng laman na isda, meron ng laman ng mga ingredients. Then there is another unit na ang ginagawa lang nila ay magluto. Sila yung nagluluto ng sealed na can na. And yun yung series ng production, no? So in every unit of production, merong shop steward. So parang siya yung pinaka-head, unit head ng production unit na yon. And so in a case na wala sa collective bargaining agreement, hindi masyadong specific as to the manner of handling grievance, or pag walang grievance committee that would readily entertain a grievance, then it should be the head of the production unit who is the shop steward that would take charge of the grievance. And if the grievance is valid, then that is brought to the immediate supervisor. And then if no settlement is reached, then it has to be referred to the grievance committee. And then it would be the grievance committee that will determine or will decide the case. Conciliation or mediation is a special form of industrial diplomacy, whereby a third person, ito naman, imbes na within the business unit siya, like a grievance committee, ito naman, outsider siya of the business unit that would try to resolve yung grievance and tries to narrow issues of dispute between the union and the management and propose solutions acceptable to both sides. So you take note of the definition of conciliation or mediation. There are two types of mediation. It could be preventive mediation and grievance mediation. Pag preventive mediation, even before the happening of a grievance or the identification ng actual na merong grievance, ay meron ng steps no na gagawin to identify yung possible causes of conflict or possible causes by which it will bring about yung grievance from the employees or the labor union or from the management. And in such case, parang early detection na siya, magkakaroon na ng mga early intervention, magkakaroon na ng mga preventive measures in order to prevent yung escalation ng grievances or conflict within the bargaining unit. Then you have yung grievance mediation, no? Which means that mediation services give attention to grievance settlement. Pag meron ng existing na grievance settlement, no? And so in such case, there could either be conciliation or mediation to prevent problems, no? That would cause economic warfare or that would cause escalate conflict between the labor and management. Where the parties themselves agree to submit their issue or issues to third person or board, the procedure is known as voluntary arbitration. If there is an intervention of the government, then it is compulsory arbitration. Arbitration is the reference of a labor dispute to an impartial third person for determination on the basis of evidence, arguments presented by the parties who have found themselves to accept the decision of the arbitrator as final and binding. Ito yung you refer no to somebody who could make an impartial judgment as to determine possible solutions to the issues or to the grievance that is presented. As we have emphasized, parties to a collective bargaining agreement shall designate or name in advance during the negotiation of the collective bargaining agreement the voluntary arbitrator or panel of voluntary arbitrators that would be called upon in case there is a grievance or even for the selection for voluntary arbitrators, and preferably yung voluntary arbitrators or panel of voluntary arbitrators would come from a list of qualified voluntary arbitrators that are accredited by the National Conciliation and Mediation Board or the NCMB. In case the parties fail to select a voluntary arbitrator or panel of voluntary arbitrators, the NCMB shall designate the voluntary or panel of voluntary arbitrators as may be necessary. The types of stipulations in a CBA, economic provisions, those which are subject to monetary estimation, no, like wages, like paid vacations, no, pensions, health and welfare plans, other fringe benefits. Ito yung fringe benefits, these are considered compensation, no? Like yung mga rice allowances, yung loans that are being extended for housing loan or mga car plans, yung mga ganon. Kasama lahat yon, pwedeng kasama lahat yon na maging bahagi ng collective bargaining agreement. And also yung non-economic provisions, those provisions that are not subject to any monetary estimation, like policies pertaining sa no strike, no lockout, union security, check of clauses, yung the manner of deducting union dues, no, and also about the grievance procedures. Submission agreement is a written agreement by the parties submitting their case for arbitration. No. And notice to arbitrate refers to a formal demand made by one party to the other for the arbitration of a particular dispute. So you just take note of the definition of this. EVAS, these are ex officio voluntary arbitrators, regional directors, assistant regional directors of DOLE are designated as EVAS, ex officio voluntary arbitrators. They have jurisdiction, EVAS have jurisdiction to hear and decide all grievances arising from interpretation or implementation. So it means that after yung exhaustion ng grievance procedure within the plant level or even in a manner that is provided for sa collective bargaining agreement, pag wala pa, then the EVAS would intervene anytime as voluntary arbitrators for the settling of grievances and other issues of conflicts between the labor and the management. The Secretary of Labor also, Labor and Employment, likewise refer to EVAS, yung voluntary arbitration cases that in which in his assumption of a labor dispute, remember yung napag-usapan natin that anytime the DOLE secretary would assume labor disputes or issues, especially on industry that are of national interest. And so if the DOLE exercises its assumption power or assumption authority over a labor dispute, then he could at any time refer this to EVAS for voluntary arbitration. The powers of voluntary arbitrators, first, of course, is the adjudicatory power. You are already familiar with the meaning of adjudicatory power. Now, we have discussed that when we discuss on the power of labor arbiters to determine or to assume yung mga labor cases, no? And adjudicatory power pertains to the power to hear and to receive evidence and to make a resolution or decision with respect to issues or labor disputes. No? Compulsory power is the power to compel the attendance of witnesses and also for the production of documents which would be required for the settlement of issues. Power to conciliate and mediate pertains to the initiative, no, by the voluntary arbitrator to reconcile or to make a mediation in order for the parties to reach amicable settlement or to come into a voluntary settlement of the issue na hindi na yung tatagal pa at magkakaso-kaso, no? So at any time, at any stage of the proceeding, the voluntary arbitrators would exert all the efforts that the parties would reconcile and sort out their differences on their own. Power to encourage the parties to enter into stipulation of facts. Ano yung stipulation of facts? These are facts that the parties would agree, no? And from the facts that they would agree on, then mas madaling ma-sort out kung ano yung conflicts, no? And so usually even before yung sa trial, the parties would already agree, make a stipulation of the facts that they agree on. And this would facilitate the speedy disposition of the case. Power to issue writ of execution. In case there is already a final decision, then that decision has to be executed by virtue of a writ of execution to be issued by voluntary arbitrator. So, parang equivalent din sila ng judges, no? Kaya lang, it's more, meron lang silang particular na jurisdiction din, katulad ng sa labor arbiter, meron siyang particular na jurisdiction. In here, sa mga voluntary arbitrators or even yung mga Med-Arbiters, no, yung concern nila is more on the interpretation, implementation of yung sa CBA, and even yung sa personal policies, no, implementation of personal policies. Unlike yung sa jurisdiction ng labor arbiter na these are outlined, readily provided for yung sa provisions ng sa labor code. So kanya-kanya silang jurisdiction. The NCMB shall maintain all records pertaining to voluntary arbitration. In all cases, the board shall be furnished a copy of all pleadings submitted to voluntary arbitrators and even yung mga orders, awards, decisions issued by the voluntary arbitrator. So that would now be the end of the lecture on grievance machinery.